everyone. Welcome to Capello Rose Family Law Principles webinar. So we're discussing family law during coronavirus today. Today's Friday. It's a bitterly cold and miserable day. But if you're joining us today, thank you for coming along. We want to make sure that we're available to anyone who's going through difficult times, particularly arising from coronavirus. And we understand with family law issues, it's a stressful time as it is. So we want to make our resources available to anyone to get as much information as they can to try and help through this process. So today we're going to be giving a bit of an overview. If you are joining us, you have the ability to ask some questions throughout. You'll see at the bottom of your screen there's a Q&A button that you can submit some questions. Today we're going to be doing that anonymously, so I won't be reading out the name of the attendee asking the question. I'll just read out the question because we understand this is a very discreet topic and we want to make sure that everyone's privacy is protected. So you can submit a question, or you can also use the chat function. We'll also be sending through these presentation slides after the presentation, and this is also being recorded. So we'll be posting this onto our YouTube channel so you can watch it at a later date. But today we have some wonderful hosts with us who are very experienced in these matters. We've got Enes Tepe, who's in our Sydney office, who's one of the partners. Hey Enes, can you hear me?
Yep, loud and clear. Hello.
And we've got Paula Johns, who's in our Griffith office. Hey Paula.
Hi all, welcome.
Enes and Paul are both very experienced in family law matters, and they're going to be talking about some case studies today, as well as an overview of the process that you need to follow. So I'll be handing over to Enes and Paula, but as I mentioned earlier, if you have any questions, and submit them at any time, and I'll be monitoring them, and we'll deal with them as they arise. So over to you, Enes.
Right, well, thanks, Sarah. So I don't want anyone to quote me on this because I could be wrong, but the first point there is that family law is, by its very nature, very highly stressful and emotional. I think it compares to losing a loved one or a job loss. I think those three things, death, divorce and job loss, I think interchangeably, depending on the psychological study you read, your top three things that cause, you to enter into turmoil because it's a massive catastrophic change in your life. So the main stress really comes from that question there. So what is next? Because you can imagine whether you're de facto, whether you're married, even if it's for a short marriage by the definition of what us family lawyers call short, something under 5 years. That's a significant amount of time to be living this joint life with someone. And now, you're left sort of holding these pieces, wondering what's the next step forward. So that's on a normal day. That's how stressful it is. But the reason that we wanted to hold this conference, webinar, was because obviously these issues are sort of exaggerated by this pandemic. So a couple of months ago, the main issues that were coming about from family lawyers were, in regards to the actual physical restrictions of where you could and couldn't go. For now, that seems to have lifted slightly, but there's murmurs of a second wave. We'll see how we go, and that might become a live issue again. But a lingering thing is the market forces that we're going to be left battling as we move forward with our lives. So, an easy example is if you ran a business and the business got valued at $500,000, what's the value of the business today? Is it going to go into liquidation? Is it going to go into administration? Do you need to hit pause on it? So the other part that we wanted to talk about as well was its intersection with estate planning, because a lot of people, when they think family law, on top of divorce and separation and children and the division of assets, they also think about what they're going to do with their estate, what they're going to do with their legacy, what they're going to leave to their family afterwards. And we want to also discuss that intersection between, if you are separated, what you're going to do with your estate planning thereafter, or even if family law to you is about your estate planning or your estate litigation, how that's impacted with coronavirus and how that's impacted by, the economic woes that we're facing at the moment. So moving on to the next slide, which is mainly about separating. And the way that we want to conduct this is, rather than simply me talking in a monotone fashion and talking off the slides, is Paula and I, we want to talk about the topics on the slides generally, and then we want to delve into case studies that we've been experiencing for the past few months in relation to the issue. So the first is separating. So what's the separating is not a legal definition. There's no legal test for separation. It's simply when one or both of the people in a relationship determine that that relationship is over. So so the most important thing when you do separate is to ensure that you do stay safe. So luckily for most people, the overwhelming majority of people that do separate, this isn't really an issue because, luckily, impacts of family violence, domestic violence, although, the media does, paint a gloomy picture because that's what makes the news, the overwhelming majority of separations don't intersect with that unfortunate area of law. But where they do, it's important to keep your safety absolutely paramount. And, there's no point calling your solicitor if you care for your safety or if you have, if you have safety concerns, because we can't really come to your house and stop something getting out of hand, but, call the police if something's getting completely out of hand. Paula, I'm sure you've had a few occasions where you've had a client call you and, say he's at the door, she's at the door, and
absolutely. Don't call us, call the police. They're very well equipped to deal with those situations, and they can also refer you out to some very good resources for people who are in acute need in terms of women's refuges and financial assistance. So I agree with you. And as first priority is always safety.
Yeah. So then if safety is not a concern, or once you do alleviate your safety concerns, the next step is, what's going to be the workable scenario? Now, as lawyers, we're often, categorized into wanting to go to court. We're itching to get something filed and stand up at court and have this great big waffle about your case at a time.
That's the perception. I don't know if that's really what it's all about.
It's the furthest thing from the reality, because what I often tell clients is if I could fit one case into a blue manila folder like on Suits, that client would not want to employ me because that means that case is very basic. So it's usually in about 9 or 10 ring binders getting taken up to court by the junior solicitor cursing you for sending them up. And there's a lot of preparation involved. But if you're in an amicable position with your partner, it's fine to just discuss what these workable scenarios are with your partner. So having the discussion and maybe trialing something doesn't necessarily mean that you're held to that decision, because the law and the courts understand that separation is a fluid process. They understand that there is a little bit of a trial run in this, particularly with parenting. That's one example that's very easy to imagine. If you have children and they're used to seeing both parents every night of the week, and then now all of a sudden one person leaves the house and they're going to have maybe seeing dad or mum or whoever on alternate weekends to start with. It's important to have that sort of fluidity in that in your communication, if possible. This is me being very optimistic and hoping things are at its absolute highest. But another live issue as well is who's going to stay in the house. Now, although there's no real strict legal position for, whoever stays in the house at separation remains with the house, it does tend to, in my experience, turn into a bit of a king of the hill battle. So it's usually whoever's in the house at separation can usually manage to stay in that house until the final orders are entered into or the final agreement is reached. So if it is that you cannot leave the house because you can't find alternate accommodation, I think it's something that's very important to discuss with your partner, because you can imagine if you leave the house and then you want back in and your partner simply says no, you either engage in a war of entering the house when they're not in there and changing the locks every so often, and all that causes the locksmiths to get really rich in whatever town you live in, as well as the court to shake its head saying, what are you guys doing? So,
sorry, Enes, can I just interject
there?
Because this is a subject that we obviously have a lot of questions about. And that is, you often have a situation in which people come to you and they say, well, look, I'm on title, he's on title,
mm-hmm.
Who has the right to stay, and is there anything I can do to exclude? And that obviously is a very difficult legal position to be in. And can you speak to that just a bit?
Well, yeah, and that's sorry. Thanks for clarifying that. That is the difficulty of the that locksmith ping pong battle, which is a case that we've actually had. I think we had that together, Paul, if memory serves.
We've had a few of those actually.
Yeah. Or I've had one with Sarah actually, which was even uglier when the husband waited for the wife to go to the shops, then hired a private security team and blocked the driveway.
Interestingly, though, remember, Edison, that one, the husband wasn't even on title. It was only the wife who was on title. And when the police arrived, she said, "I'm the only one with title to the house." And they said, "We don't care. It's a marital dispute." So it's often not relevant whose name the house is in.
Exactly. And we'll get to why it's irrelevant at later slides, because it's to do with the way that property proceedings are dealt with. And but going back to what you were saying, Paula, the reality is that until you reach an interim agreement with your partner about what the state of affairs are going to be while you guys negotiate your settlement, if you can't negotiate it on a final basis relatively quickly, the reality is that you both have legal rights to that property. Now, you can imagine if we put the brush of realism on a hypothetical scenario, imagine a house where you have 2 kids in there. Let's think of it as a pretty standard family, husband, wife, 2 children under 10, where, you know, they're having mum and dad have a fight out the front of the house over who gets to enter and who gets to leave every so often. That's why it's important to have these discussions with your partner. And often, I mean, Paula, I don't know about you, but I find that if you frame those discussions with what's in the best interest of the children as to who stays in the house, I think that it's a lot easier I think it's a lot easier to negotiate that point. So moving on to the other important thing to discuss is finances. So, oh, sorry, Sarah, could you go back one slide?
Oh, sorry.
Yeah, that's okay. So finances, obviously in the immediate term, and Paula, you've had a few of these, I know, because we've had a few phone calls about this, is, you know, when one spouse just stops paying the mortgage.
Yeah, so obviously that's an incredibly difficult position for a person to be in, particularly during the current pandemic, where there might or might not be issues around the stability of employment and access to social security benefits. Some of that is not being resolved as quickly as it should. And so, yeah, that's obviously another common predicament in us that we get a lot of.
Yeah, or the ugliest matters I find is when you have 2 spouses that are in a partnership. And how do you amicably continue to conduct a business while you're having a fight at home over how to continue the finances? So I'll give you a clue. I wish I had a simple answer to that one. There is no simple answer to that one, unfortunately. It's but
it might be worth you just talking at this point, if it's not asking too much, about contributions post separation. So what actually happens when one person is not in a position to continue to pay the home loan, the other one is, you know, maybe the formal settlement process takes a year, maybe it takes 2 years. I think Sarah and I had one that took about 5. It pertained to a farm.
Yeah.
What happens when that person says, well, you know, I'm not even in this house and I'm paying tens of thousands of dollars, paying down the home loan. You know, why should I do that when there's really no certainty about whether or not that would be adjusted in my favour?
Well, there is no certainty. The certainty comes from the strength of you being able to put forward your position, obviously, whether through legal representatives or yourself. But there is a formal mechanism in the legislation because you are making what's known as a post-separation contribution. So, easy example, if the mortgage was at $500,000 owing as at separation, then after a year of, well, let's be realistic, it's 2 years, 3 years of negotiation with the example I'm about to give, and it goes down to $450,000, then you can literally say, well, I've contributed $50,000 towards the net value of this asset. I want to be recognised for that. Now, whether you get recognised for that at 100%, it depends, of course, on the facts of each case, but you could, in theory, what I have done previously at a mediation, scratch that in theory, practically what you can do is, if the split was meant to be 50-50, you can add it back to the pool informally and then say, look, on a 50-50 basis, I want to be recognised for 50% of this contribution. And then there are ways to account for it, but it's important to draw a line in the sand in your finances and to moving forward with your financial relationship with your partner to ensure that there is that division. So
but this just demonstrates the need to try and get things sorted quickly, though, doesn't it?
Yeah, exactly. Because you can, I mean, Paula, I know you've had one of these. I have a couple of these on the boil at the moment where, you know, separation happened 3 years ago. They still operated a joint account. They still, you know, paid the mortgage jointly. And then now that one of them has repartnered, all of a sudden this beautiful amicable relationship, as in the kids will never notice, has turned sour, and they're at each other's throats. And now they're effectively, they're paying accountants a lot of money. Yeah, they're paying accountants a lot of money to be able to forensically see what the post-separation contributions were in this one particular case. But
yeah, that does strike me as being an area that seems to create a lot of problems, is where people start off saying, oh, look, we'll sort this out ourselves. And, you know, maybe in a year or two when we're in a position to finalise things, you know, we'll agree on things now and everything will be fine. And I think the current environment demonstrates that if you leave it a year to try and resolve things formally, there is so much that can change in 12 months in terms of differences in valuation. It's very difficult to know how this pandemic is going to impact on valuations for the family home. So I think one really key concept is around understanding that the value of the pool of marital assets is not going to be assessed necessarily at the day you separate. It may be that the pool of assets is valued at a much later time when you're looking at actually finalising formal settlement.
Yeah.
So this is on the next. Oh no, sorry, I've gone too
far.
Yeah,
we're going to go into that.
Sorry.
in a couple of slides. So if
go back to parenting.
Yeah, maybe we'll go to parenting and then we'll go into property. So, I mean, parenting is you know, the ugliest side of family law matters by far. It's probably what makes most practitioners stop practicing family law. I was expecting a few reassuring nods from Sarah and Paula then.
Well, I've never dealt with I don't deal with parenting matters.
I was actually going to make the point that, you know, it's not entirely unheard of to have very sensible, pragmatic people walk into your office and say, look, we've resolved what we're going to do with children. And I think, you know, if you need to walk into a solicitor's office to resolve how you're going to parent your children, that in itself is a fairly ominous sign.
Well, what I often tell clients is that think about your parenting of your children if you hadn't separated. There's no need for a parenting plan or a parenting orders. It's all fluid. It's all, you know, you do this one week, do this the other week. And then now, if you can't reach that level of amicability for your future parenting of the children, then, you know, you're effectively putting on this rigid structure on top of it. And, you know, sometimes you need that. There's nothing wrong with that. But you're right, Paul, on what you said. So, look, parenting at broad strokes, because this is just obviously general advice, because even when we answer your Q&A questions, you know, the reason that the lawyers reply, it depends to all these hypothetical scenarios, is because the devil is in the details and it's all contextual. So like every single family and every single marriage is its own special formula of madness. Every single settlement and every single parenting order and every single property order has its own little sprinkle of madness on top of it as well. So what's right for your mate at the pub or for the girls at your yoga class is not going to be right for you. So that's probably the number one thing I can say about parenting matters. It's going to save you a lot of pain. So
I remember one, sorry to interrupt, and as you saying to me, advice you'd given a client, which I thought was really profound, was a client had complained to you about some conduct of the other parent. And you said to the client, would this have been an issue before we separated? And the answer was no, it wasn't an issue, because that's just how they parented their child. So as you mentioned earlier, it's important to consider how you would have done it pre-separation. And, you know, and a lot of the time you want to apply that same common sense.
Yeah, well, that's all right. So that particular example, just for the listeners as well, was I had a phone call. It was an urgent, Ennis needs to call me back, urgent message on my email. So of course I was very worried. So I called that client back, and the client said that she had received disclosure from their 12-year-old daughter that the father had drank a whole bottle of wine with his new partner while cooking dinner. Now, I don't want to reveal too many cards close to my chest, but that doesn't really seem like an excessive amount of wine to me. so when I did talk to the client, and I think I talked to Sarah straight after I had that phone call, was I said, well, how much wine do you drink while you're cooking? And she goes, well, that's not the issue. The issue is I know he can't handle his alcohol. So that's when we had a very difficult conversation. And we explored the fact that they had both shared bottles of wine while cooking previously. So it was perfectly normal behavior for the child. And the child's 15 anyway. So even if you get a bit slurry and I guess...
So I guess it does come back to the particular circumstance of the case, because if you have a parent, for example, who's an alcoholic and they have it, even if it's a bottle of wine shared with somebody else, which to another person would be reasonable, it might not be reasonable to them. So again, this is where your particular circumstances come into play.
Yeah, exactly. Yeah. So exactly. So parenting as a whole is, parenting as a whole is, there's two primary concerns for children, right? So the first one is to ensure that the children or children have a meaningful relationship with both parents. And that has to be balanced or offset against protecting that child from unacceptable risk of harm. Now, the key word there is the word unacceptable. So bottle of wine example that I gave, that's not an unacceptable risk. An unacceptable risk from experience has been a plate in a kitchen that a child found that had residue of cocaine and other illicit substances on it. That's probably an unacceptable risk. Dad having a house party, inviting 30 people over while you're caring for your 3-year-old, not unacceptable risk, but you probably should give your kid to your ex.
Depends on the party, I guess.
Yeah, exactly. So now the presumption is that both parents are going to have what's known as equal shared parental responsibility. Now, that doesn't mean time. That just means actively being involved in the long-term decision-making of that child. So not whether the child should have McDonald's or Red Rooster that night, but whether the child should go to an Anglican boarding college or a public high school. That's the sort of division there. So but the key question, and what makes matters drag on, is that third dot point there is, how do you structure the children's time, right? So how do you go, like what we foreshadowed earlier, how do you go from spending time with your child at will, or sorry, reverse that, your child spending time with you at will, so they can just walk down to the hallway and see that dad or mum's there and can show the drawing or whatever beautiful example comes to mind, to, all of a sudden not having one parent there. And that's where the biggest it depends is. So 50-50 is not always the right answer. And we'll get into some examples here between Paula and myself. I mean, I've had a case where the husband and wife lived 2 blocks from one another, but the wife was adamant that 50-50 time would not be acceptable for their 12-year-old son. Needless to say, that case didn't really get far because the 12-year-old son expressed his wishes to the family report writer and said, I want to have 50-50 time. I can go to the same school. It's the same bus. It's the same bus stop that I can get off at. Conversely,
that's a really good question, and one that I get often is, to what extent children and at what age are they able to express their views about where they want to live, and at what age is it impracticable to compel a child to live with one parent when they just don't want to?
Well, it's the answers, it depends, but not as cloudy as what I've said previously. I reckon the shoulder age is probably about that 11, 12. Because if you cast your mind back, well, not even cast your mind back, just think of any 12, 13-year-old that's sort of, you either have a very immature 12-year-old or a very mature 12-year-old. Do you get what I mean? So a very mature 12-year-old will be able to articulate what they want, could tell you the reason that they want that. So the child's views would probably hold a little bit more weight in that case. Whereas if you have a 12-year-old who's more concerned about the latest PlayStation game that comes out, nothing else, and is more acting like a 10-year-old or a 9-year-old or a male 12-year-old, it may be that 1, they don't care, or 2, that they just don't really have the maturity to be able to express an opinion that would be able to also express what would be in their best interests, because what the child wants is only one of a myriad of factors. And, there's a reasonable practicality with being, the bus stop example. I mean, if you have one client who lives, and this happens to a lot of our Griffith cases, as you know, Paula, you got one party who lives in Griffith and then the separating spouse moves to Melbourne or Sydney or what's another one I've had, Kununurra in Western Australia. obviously you're not going to have 50-50 time. It's going to be school holiday times only, because you can't get the bus from here to Perth and back in reasonable time. So have you had any good examples with reality checks with clients, Paula?
Look, it's probably a good segue into some questions that I've had that have been very specific to the pandemic.
Yeah, I think so.
And that is that, we've had a few clients who've, on both sides, in fact, who've called and said, look, I've got this situation in which I've got children moving between households. I feel that my ex-spouse is high risk for one reason. Maybe they're working in health, maybe they're exposed in some other way. I have these real concerns about exposure to risk. Or on the other hand, it might be a parent who suddenly finds themselves getting angry text messages from a partner saying you're not having the kids back because you're high risk. And I know that we had one that happened recently and you were actually able to resolve it quite quickly. So did you want to speak to the specifics of COVID-19 and parenting when you've got these vexed issues around exposure to risk?
Yeah, so it comes back to that initial primary obligation to keep that child away from an unacceptable risk of harm. Now, that's why that keyword is unacceptable. Now, that example that you're talking about, Paula, was our client, and he received a text message saying, you're not going to get the children because you're a frontline worker, and all this other colourful language that went along with the reasons supporting it. So what it took was effectively me writing to the wife personally, because she wasn't legally represented, the ex-wife, sorry, and saying effectively, one, there's no unacceptable risk of harm. I got my client to take lots of photos of his workplace, as well as an email from his HR department of his work about what their COVID-19 policy is, as well as, and quite helpfully, the Chief Justice Ostergren of the Family Court released a media release, being a four-page letter to all parents involved in parenting disputes because of COVID-19, that they have to remain sensible and practical for situations like this. So in that situation, it wasn't sensible at all. I mean, I'm sure she ended up getting legal advice, and the legal advice told her, you can't maintain this process. But luckily, our client as well turned around and said, look, I'm not going to go after her for, legal costs or anything else like that. I just want the time to resume. He missed out on 2 nights. He didn't really care too much. And it's a good story for him, a good turnout for him. But conversely, I've had a nurse call me, and then the nurse is obviously in hospital, and the husband didn't want to release the children to the nurse because she hadn't been tested, and it wasn't like now where you can get a test result in less than 24 hours. It was towards the start of the pandemic, and I had to give her the bad news, saying, look, think of your kids here at the first instance, is the possibility of you contracting it, because we didn't know too much about the community transmissions as much as we do now. I essentially told her that, there's no point having this dispute, because it's a lot quicker for you to just go get tested, get the negative result. If it comes back negative, even the text message, then get your children. It'll cost you a lot less than legal fees, and it's a practical solution to the matter.
But I guess in that case too, it's also thinking about what you would have done if you weren't separated. And I know a lot of people who were healthcare workers were actually self-isolating from their families, even if they weren't a separated family. So sometimes it's saying, okay, even though I really want to see my children and I want these orders to be in place, what would we otherwise be doing in the best interest? It always comes down to that, doesn't it?
Well, that's right. So not to make it too technically legal, but I mean, even if you have orders in place that say that you're meant to have 50-50 time with a kid, for example, an excuse for contravening those orders is a reasonable excuse. I mean, I in the past 2 years, 3 years, haven't drafted any orders with the forefront of my mind having a pandemic there.
Yeah.
I think about a self-resolving mechanism to maintain parenting through the pandemic. So you're right, Sarah. It's just I think that's pretty much parenting. The approach to parenting in a nutshell is, what would you do if you guys weren't separated? What approach would you take?
Yeah, we'll just go through to the property quickly, because we're at the half an hour point, so we want to try and keep this to 40 minutes or so. Okay,
no problem. So property touches on what Paula was saying earlier, is in that the asset values aren't necessarily going to be taken as at the date of separation. They can be, and the reasons that they can be, for example, going to the post-separation contributions argument. So, for example, if if a couple has a business and then one of the couple leaves the business, and then because the remaining partner makes the business flourish, they can possibly turn around and run an argument to say it was through my contributions post-separation that business is worth what it is. But you have to be careful of that argument, because it can sort of come back and bite you in the arse. But we'll come back to that in a minute. But the first step for any property proceedings is to understand what's in the pool. So you get that by having full and frank financial disclosure, which is, providing all your bank statements for the past 3 years, providing all your tax returns for the past 3 years, super, all that sort of stuff, so that you can see what the value of everything is as at today's date.
And as we should also clarify that the disclosure is mandatory.
Yes, that's right.
And the clients never like that part.
No, clients
they
don't like
resist it like the plague, and or like they resist it like COVID, but they have to still provide it.
That's right. So because the ramifications if you don't disclose are, assuming your matter goes to a hearing, the judge is going to think that the reason that you didn't give that document is because there's something you have to hide. It's that simple. I mean, it's annoying downloading all your NAB statements or CBA statements, but it's a lot more annoying having to give your ex-spouse another 50 grand because you couldn't be bothered doing it.
But I remember once, Paul, you gave some really good advice to a client where you said it's important to connect your lawyer with your accountants and all your other advisors to make sure that the information that's coming through is actually correct, because often clients don't understand, particularly if you've got a complicated business arrangement, they don't understand their own structure. So there's things that can be overlooked. So you want to get your lawyer and your accountant to be talking directly, and obviously the client's involved as well, but just to make sure that all of the advisors are on the same page.
Well, that's right, because they know more than we do, because we sort of come into the matter for a very, very definitive reason, and that's it. Whereas your accountant financial advisor's there with you every step of the way usually. So so with full and frank disclosure, it's very easy to get your account balances and your credit card liabilities and your home loan mortgage, but there are valuations that may not be agreeable. So for example, the value of the matrimonial home. A common example is the party who wants to remain in the matrimonial home obviously wants the value of that to be as low as possible. And the party who wants to get some cash for getting out of the matrimonial home, so the property settlement, a lump sum or something in their favour, wants that valuation as high as possible. And you can see naturally why they would want that. So where there is a disagreement, the rules are, and these are the family court and the federal circuit court rules, are quite simple. If you don't agree, you need to jointly get a valuer, and that valuer's valuation is the figure you adopt. So if you say that...
What happens if you had, sorry to interrupt, what happens if you had a valuation, say in January pre-COVID, and you were negotiating on that basis? What would be your advice to your client in the current circumstances?
Well, so this is where you have to be careful how you proceed, right? So, and I can answer your question through giving you an example that just happened last week. So last week we had a matter settlement mediation, and the client's business was he supplied a whole goods into David Jones and Meyer, being 90% of his business. So with that example, his business got valued at a certain amount. And then he obviously was concerned after the valuation was at 30 June 2019, and he obviously had concerns because the value of his business pretty much stemmed from the supply orders that he received from David Jones and Myers, who are both in a lot of trouble because of this pandemic. So now you have to be careful, because on the face of it, you have an argument to either talk to the lawyer on the other side and say, look, we're going to get another valuation and get the business revalued to take into account the pandemic. Or if they disagree, you can approach the court for the court to make those orders, justifiably so. But the mistake that a lot of clients make is they look at these disputes as if in a very micro fashion instead of a macro fashion. So this particular client, I outlined to him that if you look at it in a micro fashion and we say get the business revalued and it gets revalued at half, they in turn have an argument to say, okay, let's just hit pause and let's get the business revalued after the pandemic's over. Now, this particular client had a lot of stuff on the boil that were going to come through pretty much after the pandemic came through. So he made the commercial decision at that point that if his business is worth, let's say $1 million as of 30 June 2019, it very well could be that if you were successful in hitting pause in the proceedings and you recovered as you planned to from the pandemic, then it could be worth $2 million. But it's easy to think of an example on the contrary. Yeah, I mean, if it was that, you had $300,000 worth of supply orders that were outstanding from DJs, and DJs goes into administration, then the business gets liquidated because you can't afford to pay your creditors in turn, then it's very well not in your favour, but the right thing to do for both parties to get that business revalued or to hit pause to see what happens.
So I'm getting a look at your circumstances. This often comes up, I always find, in inheritance arising during a separation. So if a parent of the parties dies and then there's an unexpected inheritance, I think, Paul, you've had a case similar to this, and how that's dealt with, because it's kind of, it wasn't anticipated, and this is, I guess, more incentive to try and get these matters resolved as quickly as possible.
Yeah, I think that's a really good point, Sarah. I think, always generally we say it's better to settle things as quickly as you can for many reasons, because things can change either way. But the reality about inheritance is it is to a great extent dependent on the timing of that inheritance. So if you had an inheritance post-separation, it would be very difficult for the non-inheriting spouse to argue that should form part of the pool. Difficult, not impossible.
Yeah.
As with all of these issues, we should make a general disclaimer to say it depends. It depends. I mean, did the exiting spouse nurse, their father or mother-in-law? To what extent, were the contributions of the non-inheriting spouse relevant? So it really does depend. But certainly it's something that not only the separating parties, but their parents should also bear in mind in terms of the way that inheritances could be structured if there's potentially vulnerable beneficiaries involved.
Yeah, well, there's a good segue into the estate planning section of the webinar, but I've got a question come through. Does it matter who contributed what during the marriage when the settlement is arranged?
Well, yes, because after you determine what the pool is, the next step you have a look at is you have a look at who contributed what to the relationship. So financial contributions are one. The easiest one to think of is income. Other ones are, things such as inheritances, so big lump sums that come through the relationship. And also is non-financial contributions. So stuff like who's taking care of the kids, who's doing the housework, who's good with their hands and put on a patio that increase the value of the house. And then the other part, and the way it ties into what Paula was just saying as well, is although an inheritance that might come post-separation may not be part of the matrimonial pool, it still gets taken into account in family law proceedings as when the court's assessing each party's future need in making the offer. So that's where it comes down to, I don't know what the dollar value is, and it's obviously varies from person to person, but for me personally, not legal advice, but my personal thing, I value certainty at a very high dollar figure. So if I can get a certain outcome quickly, to me, that's invaluable. So, you don't want to have a negotiation where you're about to settle and then have an inheritance of $900,000 come through, and then that to come off the table because, the lawyers on the other side of the matter or the party on the other side of the matter will say, well, that's not fair. I'm going to get $500,000, but then you're going to have $900,000 plus $500,000. So I should get more of what's in the pool because you have this big kitty on the side.
Yeah. I've just had a flood of questions come through, so I might just read them out, but then also they tie into, Paula, where you're going with the estate planning, because it's asking what are the first steps I should take, so particularly if we're stuck together in the same house. So I guess if we kind of outline the steps and incorporating that, Paula, you want to talk about your estate planning as part of that as well, because it has a lot of relevance with what we're discussing now. So the question is the first step I should take if we're stuck in the same house. If you're thinking of separating, sorry.
Look, taking aside, I'm sure that Ennis will have some very good pointers from a practical family law perspective, but there are some very sound reasons to update your will. And I think the most important of those is that, heaven forbid, in the very unlikely event that you were to pass away, it's pretty galling for your family to have to deal with your ex-partner or spouse in relation to making funeral arrangements and having no real control over your affairs. So, Ennis, did you want to comment on immediate steps from a family law perspective?
Yeah, so assuming that safety isn't a concern, we have to put that out there. But assuming that safety is not a concern, and let's assume that this was 2 months ago where there's a good chance that you physically could not leave the house without getting a massive fine. If you think about separating, the first step is to tell your partner that you're thinking about separating, and have that discussion with your partner practically. So if you're stuck together in the same house, you still should have that conversation with your partner. I'm not going to sugarcoat it and say it's going to be an easy conversation. I'm sure it's going to be difficult and awkward, to say the very minimum. But then after you get over that initial shock of the separation declaration, if we will, then you can talk about the practicalities of dividing your financial relationship to discuss, or if you can't divide your financial relationship, for example, if you bought 10 properties since 2012 and everything's leveraged together, then you can discuss how you guys can manage your finances moving forward, or how to tell the kids, whether to tell the kids. I think also it may be important, and I'm not trying to put a plug in here for us specifically, but it may be before you make the separation declaration, as I've deemed it now, it may be good to go speak to a lawyer.
And sorry to interrupt there. My recommendation would be to have that initial conference with a lawyer, so you understand precisely what your requirements are and what the process is, specifically to your circumstances. Now, what we always recommend as well is not to get straight away get adversarial. So that's, you don't want to start off on a fight, and before you have that conversation that Ennis just recommended, that your partner is going to be getting a letter from a lawyer saying, by the way, I act on behalf of Joe Bloggs, and Joe Bloggs wants to separate with you. So you have to have that conversation. But before that, if you're not sure about the process, then have that initial discussion with the lawyer. And I mean, Ennis and Paula from our firm are incredibly approachable and lovely people. So it shouldn't be confrontational. It's really about just understanding your rights. So once you've had that, once you understand it, then you can kind of manage the process from that point if circumstances permit.
Yeah, because you can imagine the awkwardness if, you don't tell your partner and then you come and see, a lawyer and you're still living in the same house, and then they open the mail, or worse, you open the mailbox and you know exactly what that letter is. Say, oh, here's a letter for you. And it's a letter saying, oh, I represent your spouse, and by the way, give me all your disclosure documents. That's probably not the best way to go about it.
So once you have that kind of overview, what Paula was touching upon as well is you need to look at your estate planning, because if something terrible happens in the interim before you actually have the divorce finalised and the property settlement finalised, then your spouse then is arguably entitled to all of the estate. So you want to have that will sorted out very quickly, just to make sure that everything's going to be as you want it to be. I mean, you wouldn't want a situation where you've had this particularly acrimonious divorce and then your spouse gets everything because you hadn't sorted out your will. And that's such a small part of it, but it's so important.
Or worse, and this might make a few people chuckle or shake their heads that are listening, is the Family Law Act specifically has a clause that say that divorce proceedings, or family law proceedings, sorry, more correctly known, don't end upon the death of a party. So when you die, and if these proceedings still aren't settled, your executor can take the proceedings on. So you have a normal mutual will relationship where, your wife's your executor, or your husband's your executor, or your partner's your executor, and they're currently having a battle with you at the family courts. You don't want them to control the dispute on your behalf. So just from the pure who controls your estate should you pass away, it's worth just getting even a basic will done, so that you can give your affairs to someone that you can.
Yeah, as quickly as possible. And often, I know you and Paula speak to clients about that in the initial consultation, saying, listen, let's try and get this sorted out as soon as possible.
Yeah.
The next two questions I have are, what do I do if my partner is not going to be cooperative during this time? I know they will fight over everything. How can I prepare for that? And the second question, which you might answer together, is how long will the process take? So what's happening if you have someone who's not going to be cooperative during the process?
Right. Well, so the process generally, the way that it works is obviously the system. The system is specifically designed so that it encourages alternative dispute resolution.
Sorry, I might just go back to the earlier slide that I skipped over, because that'll answer the question. So
yeah. So informally, what we mean by informally is either you talking with your spouse. So the golden matter for a lawyer is when you get someone walk into your office, say, look, I've come to an agreement with my spouse. Can we just codify this to an agreement? And you're happy, lawyer's happy, you're happy, it's not stressful.
And also we should say that doesn't involve like one party getting 90% of the pool when they're under some serious legal or practical disadvantage. So if they come to us and say, look, we've had a good chat about it, we think this is about right, and it falls within the range of what a court would do anyway, that's really utopia from our perspective as lawyers.
Yeah, because it's one of those rare cases where you can like walk out smiling with your client after the initial conference. So the second step of informality, if you will, is for the lawyers to have the discussion. So, it would be, you have your initial conference with your lawyer, you gather all your material, you find out what's in the pool and all that other lovely stuff. And then, it's effectively letters between the lawyers and phone calls between the lawyers and negotiations. And then you can enter it through consent orders. Now, I'm going to answer the second question once I get to the end of this ascending degrees of formality. The third sort of layer of formality, if we will, to get it settled is to go to a mediation, and it's actually mandatory prior to going to court for children's matters, and very highly recommended for property matters.
Where the partner's not being cooperative, I guess you're talking about, to try and get it resolved. But
yes.
Just keep in mind too that throughout all of this, your lawyer is going to be talking about what they believe, the range of what a fair settlement is going to be, or a fair split is going to be.
That's right. So even if it's a parenting matter and it's not even to do with property, there is a specific clause in the legislation that says that the parties must attempt mediation before coming to court. And if your partner's not cooperative, for example, to answer that question, you have a partner whose attitude is like, nah, they can get stuffed, I'm not going to go to the mediation, then you get given a certificate, and that pretty much lets you knock on the court's door and file your proceedings and get stuff going through the courts. Now, if you have a partner who's completely uncooperative to start with, it's likely that the informal steps are probably not going to do much for you. You're probably going to have to run the motions of attempting them. And when I say run the motions, I mean genuinely attempt them, but they will end up feeling like motions because they're just going to keep turning around and saying no. So what you need to do then is go to court. That's what the court is there for. Because if two parties cannot agree to something, or if one party is not willing to have a discussion about something, you need a third party intervention, and that third party's intervention is the courts. So, and the court will force their hand effectively by way of orders. Now, how long does the process take is if it's obviously completely and directly related to the degree of formality the matter needs to finalise. So if it's the case that, the golden ticket matter that Paula just said, it could be anywhere between a week to a month. If it requires the solicitors to go back and forth, depends your appetite for uncertainty. Some clients want to give it a month and then want to go on to the next step. Other clients, Paula and I have one matter that we worked on together where the client wanted the lawyers to negotiate for about 3 years because he was scared of going to court, and now we're finally at court. Answer is it depends, but generally speaking, people give it a couple of months for negotiations between the lawyers. And then if we're going to go towards court, from the day of filing to the day of your final hearing, should you need it, honestly, you're looking at a minimum of 2 years.
But isn't there a special COVID listing as well for any urgent matters?
Yeah. So what I was about to get to was the way you got to think about court proceedings is that you're on a highway, and just because you're on a highway from Sydney to Melbourne, it doesn't mean that you can't take an early exit. So the judge will always try and give you early exits. That's the analogy that I give clients all the time. So in relation to special lists, right? So Parramatta's got what's known as a Magellan list. And then there's also a COVID-19 list that's just been implemented throughout all the registries. The Magellan list is for nasty parenting matters that need urgent intervention really quickly. They'll fast track your matter through the court. Now, the COVID-19 list is for, luckily I haven't had to use it. I've been able to negotiate my way out of all of the COVID-19 issues that have come up, but it's there because the judges created this list for matters that require the court's intervention due to an issue from COVID-19. Now, it's mainly geared towards parenting issues. So, for example, that matter that I discussed earlier where the mother didn't want to release the children for my client's care, if she continued to be disagreeable to negotiate, I would have filed the matter, request that it get put in the COVID-19 list. And the structure of that list is that you have a registrar who effectively acts like a triaging nurse, and they'll probably kill me that I referred to them as a nurse, but it's the same sort of concept. Your matter goes in before the registrar gets all the key details to assign it to a judge as quickly as possible for treatment. So the courts are reactive. But in general, if you just have a general matter, from negotiation to settle in, if your partner is really difficult to answer that question, I can't sugarcoat it. I would say budget 3 years. And
I guess if you're thinking about it and you have questions, and pick up the phone and ask and speak to someone who knows, and that initial consultation is typically information gathering for both of the lawyer and the client. So it's just about getting to understand the circumstances and then trying to put you on the right path to try and get to the outcome as quickly as possible. And that's always the objective. Lawyers don't want to end up in court for this because it's not pleasant for anyone involved. But if you have to, then we'll be prepared to do so. So sorry, and so that's all of our questions today. So we'll wrap it up. But thanks, guys. That was really informative. So with Capello Row, we're really trying to focus on giving as much information to all of our clients and our networks to try and help them through this process. So we've adopted this webinar series where we're giving out information that's specific to coronavirus. So we've done a couple of webinars already on the mandatory code of conduct for commercial property leases, and also on the JobKeeper. So the next one's probably going to be on managing employees during coronavirus, particularly if you're not eligible for JobKeeper, because trying to navigate how it's going to manage employees when you're not entitled to adopt the same rules that people who apply for JobKeeper can. So if there's any interesting topic that you want to discuss, or you think it would be worthwhile us doing a webinar on, then just get in touch with us and we'll have a chat about it, or we can talk to you directly. So we want to try and help everyone through this. But any more questions for today, then just send me an email. My information will be, I'll send out a copy of this recording and the presentation, then shoot me a reply, and then we can help you through this. But thanks, guys, for today. So
can I just interject? There was just a few quite important things that I wanted to mention from the state.
Sorry, Paula.
Just purely because they're quite important to bear in mind. So just a few really quick points to make is that, first of all, the effect of a divorce is to actually revoke your will. But as we've just been talking, you'll definitely get the sense that the gap between when you actually separate and when you divorce is more than likely going to be, maybe 6 months best case scenario, but more likely to be, 18 to 24 months. So although a divorce automatically revokes your will so far as it relates to provision for your spouse, it's very important to note that that's not necessarily going to happen straight away. So really important that you update your will. Not only that, there's 2 other key estate planning documents that we always talk about. So that's an enduring power of attorney, which enables someone to make legal and financial decisions for you while you're alive. So, and if you're capacitated, more often than not. And also another document called an enduring guardianship, which is for medical, health, care and lifestyle related decisions for you if you can't make those for yourself. Now with those 2 documents, a divorce does not revoke those. So to the extent that you separate and you really don't want your spouse to make, life and death decisions for you if you're lying in a hospital bed somewhere, or you don't want them to be able to access your bank accounts and manage your financial resources if you're incapacitated, also really important to revoke those documents that are already in place in favour of a spouse and update them. So I just wanted to make that as a really important point, because and also just to say that, once you've done your property settlement, it's a pretty good bar against a claim for what we call family provision. So yeah, I mean, anything else we can talk about in another webinar, but wanted to make those points really crystal clear. Yeah,
but I guess, your lawyer, if a client's coming to you, a lawyer really should be explaining this to you. And I know that you both do that in the initial conference, is talking about the importance of doing this. So if you do see a lawyer and they don't mention this, then ask. Just say, what else do I need to do beyond, going through the motions of getting my financial documents? What else do I need to do to protect myself? So it's a really important point. Yeah. All right, thanks guys. I'm sorry to have tried to end a bit earlier, but we really appreciate you both. You're very insightful. So I hope everyone has a nice weekend, and we'll see you in 2 weeks at our next webinar.
Thanks,
guys.
Bye, thank you.
Bye.